Hello everyone. In this part, let's discuss transferee by operation of law, where an heir, personal representative, liquidator, trustee, receiver, successor corporation, or similar person who claims to be designated by law to succeed to the interests of a beneficiary presents the documents in its own name as if it were the authorized transferee of the beneficiary. These rules on transfer by operation of law apply. First of all, what is meant by transfer by operation of law? In the normal transfer, this beneficiary will request this issuer or the nominated person to transfer the standby to a third party. But in this case, the transferee can be a third party who is a successor by operation of law, that is, maybe by a court order. The reason for such succession can be anything. It may be by death or incapacity or even bankruptcy of the actual beneficiary. So, if the transfer happened by the operation of law and not by the request of the beneficiary, then this rule on transferee by operation of law will apply at that point. Next one, additional document in event of drawing in successor's name. A claimed successor may be treated as if it were an authorized transferee of a beneficiary's drawing rights in their entirety if it presents an additional document or documents which appear to be issued by a public officials or representative, including a judicial officer, and indicate. This means ISP requires any documentary evidence for considering a third party as a successor of this actual beneficiary, and it must be an additional documents apart from that mentioned in the standby. Apart from this, ISP lists down four situations where a successor need to be recognized. Remember, this is not an exhaustive list, right? First one is that the claimed successor is the survivor of a merger, consolidation, or similar action of a corporation, limited liability company, or other similar organization. This means if a company is merged or consolidated, then a relevant proof has to be submitted. It might be a certificate from the register of companies, right? Next one is that the claimed successor is authorized or appointed to act on behalf of the named beneficiary or its estate because of an insolvency proceedings, which means in case of an insolvency, then as well a person or a company may be appointed by court of law mostly as a successor. In that case as well, a relevant proof has to be submitted, right? This is another situation. And the third one is that the claimed successor is authorized or appointed to act on behalf of a named beneficiary because of death or incapacity, or that the name of the named beneficiary has been changed to that of the claimed successor. In case of death, the relevant document might be death certificate of the beneficiary and legal hardship certificate. And if the name of the beneficiary is changed, then as well any relevant proof has to be submitted as per this rule, right? These are all indicative examples and reality can be anything. That is why here it is simply mentioned documents which appear to be issued by a public official or representative, including a judicial officer. If any document which issued by any of these parties as listed here evidences this person is the successor of the beneficiary, then such document can be considered as a relevant document as per this rule, right? Next one is suspension of obligations upon presentation by successor. An issuer or nominated person which receives a presentation from a claimed successor which complies in all aspects except for the name of the beneficiary. For example, under standby, we are receiving a demand from a person who is not a beneficiary. How we found that? The beneficiary name is different. But if there is no documentary proof to prove that person as the successor, then this rule will apply. So in such cases, the issuer or the nominated person may request in any manner satisfactory as to form and substance a legal opinion, an additional document referred to in Rule 6.12 as we saw earlier from a public official, statements, covenants, and indemnities regarding the status of the claimed successor as successor by operation of law, payment of fees reasonably related to these determinations, and anything which may be required for transfer under Rule 6.03, that is condition to transfer, or an acknowledgement of assignment of proceeds under Rule 6.08, that is conditions to acknowledgement of assignment of proceeds, but such documentation shall not constitute a required document for purposes of expiry of the standby. Just remember this. If a document is not submitted for proving the succession, then the issuer or nominated person may ask all these or any of these as listed here, which includes a legal opinion from an advocate or a notary and an additional documents as we saw in the previous rule, right? Then this successor may need to execute agreements and indemnities to safeguard the issuer or the nominated person, right? Next, obviously, the successor is responsible for the charges incurred in connection with this transfer. Apart from this, the issuer may require anything with respect to Rule 6.03 and 6.08. That is, if such standby is transferred or assigned, then this issuer or the nominated person may require some other conditions to be satisfied to accept this successor, right? Now, what does this mean? But such documentation shall not constitute the required document for purposes of expiry of the standby. This means such an additional document as required by this rule need not be submitted before the expiry date of the standby. Why? Because it is not a required document under the standby. It is just required to safeguard the issuer or the nominated person. So, expiry of the standby will not affect the ability of the successor to submit such additional document. Next one, until the issuer or nominated person receives the requested documentation, its obligation to honor, give notice of dishonor is suspended. But any deadline for presentation of required document is not thereby extended. This means if the issuer or nominated person asks for any such additional documents, then until getting such required documents, their obligation to honor or give notice of dishonor is suspended. But for the beneficiary, there is no extension in deadline for submitting the documents required under the standby. Remember, this deadline not extended thereby is applicable to the documents required under the standby and not required by the issuer in addition to that required by the standby. Note this very carefully, right? So if additional documents are requested by the issuer to the successor, then until submission, the issuer is not required to honor or dishonor. But for the successor, the expiry or deadline for document submission under the standby is not extended, right? Next one is reimbursement for payment based on a transfer by operation of law. This is again the same clause in transfer, assignment and everywhere. An issuer or nominated person paying under a transfer by operation of law pursuant to Rule 6.12 is entitled to reimbursement as if it had made payment to the beneficiary. This means the issuer or the nominated person is having the full right to claim reimbursement from the applicant even if made the payment to a successor as per this rule, right? By this, we have finished Rule 6 of ISP. I hope you got an in-depth understanding of the rule. As far as this rule is concerned, try to understand the difference of transfer between UCP and ISP. Apart from that, try to read the provisions applicable to assignment as well as transfer by operation of law. In this rule, most of the clauses are generic in nature, so try to correlate with the practical situation whenever you read this rule. Right? Thank you all, and we'll meet you in the next lecture.